In employment law, constructive dismissal, also called constructive discharge or constructive termination, occurs when an employee resigns as a result of the employer creating a hostile work environment. Since the resignation was not truly voluntary, it is in effect a termination. For example, when an employer makes life extremely difficult for an employee to attempt to have the employee resign. Rather than outright firing the employer is trying to effect a constructive discharge. The exact legal consequences differ between different countries, but generally a constructive dismissal leads to the employee's obligations ending and the employee acquiring the right to make claims against the employer. The employee may resign over a single serious incident or over a pattern of incidents. Generally, the employee must have resigned soon after the incident. United States law. In the United States, constructive discharge has differing meanings depending on the jurisdiction. In California, the California Supreme Court defines constructive discharge as follows. In order to establish a constructive discharge, an employee must plead and prove by the usual preponderance of the evidence standard that the employer either intentionally created or knowingly permitted working conditions that were so intolerable or aggravated at the time of the employee's resignation that a reasonable employer would realize that a reasonable person in the employee's position would be compelled to resign. UK law. In United Kingdom law, constructive dismissal is defined by the Employment Rights Act 1996 Section 95C. The employee terminates the contract under which he is employed in circumstances in which he is entitled to terminate it without notice by reason of the employer's conduct. The circumstances in which an employee is entitled are defined in common law. The notion of constructive dismissal most often arises from a fundamental breach of the term of trust and confidence implied in all contracts of employment. In order to avoid such a breach, an employer must not, without reasonable or proper cause, conduct himself in a manner calculated or likely to destroy or seriously damage the relationship of trust and confidence between the employer and the employee. Whilst a breach can be of the implied term of trust and confidence, a fundamental breach of any of the express or implied terms of a contract of employment is sufficient. The Department of Trade and Industry states, a tribunal may rule that an employee who resigns because of conduct by his or her employer has been constructively dismissed. For a tribunal to rule in this way, the employer's action has to be such that it can be regarded as a significant breach of the employment contract, indicating that he or she intends no longer to be bound by one or more terms of the contract. An example of this might be where the employer arbitrarily demotes an employee to a lower rank or poorer paid position. The contract is what has been agreed between the parties, whether orally or in writing, or a combination of both, together with what must necessarily be implied to make the contract workable. Following a constructive dismissal, claim for unfair dismissal and a claim for wrongful dismissal may arise. Types of constructive dismissal. Although they tend to blend into one in a tribunal, strictly there are two types of constructive dismissal: statutory and common law. At common law, the requirement is acceptance of a repudiatory breach, which means the employer has indicated it no longer considers itself bound by an essential term of the contract, e.g., the requirement to pay wages or the requirement not to destroy the mutual bond of trust and confidence. It matters not if the employer did not mean to repudiate the contract. Under statute, the requirement is employer's conduct, allowing the employee to terminate without notice. As this can only happen with a repudiatory breach, it amounts to the same thing. Relation to unfair dismissal. A common mistake is to assume that constructive dismissal is exactly the same as unfair treatment of an employee. It can sometimes be that treatment that can be considered generally even-handed nevertheless makes life so difficult that the employee is in essence forced to resign. But the Employment Appeal Tribunal doubts that it will be very often that the employer can breach ERA 96s98 whilst being fair. A constructive dismissal occurs when the employer's serious breach causes the employee to accept that the contract has been terminated. By resigning, the fairness of it would have to be looked at separately under a statutory claim for unfair dismissal. The problems for the employer are that constructive dismissal is a contractual claim, which can be made in a tribunal for up to £25,000 or in court without limit, and by dismissing constructively, it by definition misses out on the correct procedure, meaning that even if the reason was fair, the decision was probably not, and so an unfair dismissal usually arises, creating a statutory claim alongside the contractual claim. The court can look behind the lack of or different stated reason given by the employee at the time of resignation to establish that a cover story was in fact a resignation caused by fundamental breach. Typical causes. The person causing the dismissal does not need the authority to dismiss, as long as they acted in the course of employment. Grounds. Constructive dismissal is typically caused by unilateral contract changes by the employer, such as deliberate cuts in pay or status, persistent delayed wages, refusal of holiday, withdrawal of car, suspension without pay, dramatic changes to duties, hours, a location, or breach of contract in the form of bullying, e.g., ignoring complaints, persistent unwanted amorous advances, bullying and swearing, verbal abuse, singling out for no pay rise, criticizing in front of subordinates, lack of support, failure to notify a woman on maternity leave of a vacancy which she would have applied for if she had been made aware of it, refusal to confirm continuity on two-pay transfer, revealing secret complaints in a reference, or breaches such as behavior which is arbitrary, capricious, inequitable, intolerable or outside good industrial practice, conduct that undermined trust and confidence, refusal to look for an alternative role due to workplace stress, disproportionate disciplinary penalty, employer cons employee into resigning. Flexibility and mobility clauses. A flexibility clause does not allow the employer to change a type of job, as it is implied that the flexibility is to operate within the original job. A mobility clause is subject to the implied term of mutual trust, which prevents the employer from sending an employee to the other side of the country without adequate notice, or from doing anything which makes it impossible for the employee to keep his side of the bargain. Insufficient grounds. There is no right to automatic pay rises, nor is a smoking ban a breach. Compensation. The employee's conduct is irrelevant to liability, although it can affect quantum. In other words, it cannot get the employer off the hook, but could reduce compensation if he helped bring about his own downfall. Timing. The conduct by the employer could be a one-off serious breach of contract, anything to the employee's detriment that acts as a last straw after a string of serious breaches, a serious breach that acts as the last straw after a string of less serious breaches, or a string of less serious breaches related in time and nature that add up to a serious breach. Employee must resign quickly. The employee has to resign within a reasonable time of the trigger, which is the one-off outrage or the last straw. The employee could work under protest while he or she finds a new job. Waiver. If the employer alleges that the employee waived a breach by not resigning, each breach needs to be looked at to see if it was waived separately. But even if a breach was waived, the last straw revives it for the purpose purpose of determining whether overall there was a repudiation. Affirmation. If the employer alleges that the employee has affirmed a breach by not resigning, the employee could point out that no consideration was paid for it and so no contract change has been accepted. Acceptance of a replacement job would prove affirmation. An employee who stays on for a year after refusing to sign a new contract does not necessarily accept it. Last straw. The last straw does not have to be similar to the earlier string of events, or even unreasonable or blameworthy. It need only be related to the obligation of trust and confidence, and enough that when added to the earlier events the totality is a repudiation. Notice period. Although the employer's breach must be serious enough to entitle the employee to resign without notice, the employee is entitled to give notice if they prefer, so that they could enjoy the benefit of wages during the notice period. To prevent the employer alleging that the resignation was caused by a job offer, the employee should resign first and then seek a new job during the notice period. During the notice period, the employer could make the employee redundant to summarily dismiss them, if it has the grounds to do so fairly. Otherwise, the reason for termination will be resignation and not dismissal, since the employee cannot serve a counter notice.